I'm starting the recording now. This is being recorded, this session, for the benefit of you guys out there and for the benefit of our mutual clients. We'll be posting this later, I think. So anyways, yes, it's great to have to be having this webinar, which is today, focused predominantly on Israelis or Americans and Israelis, Americans that have contacts in Israel. We're doing this with Shira and Trevor, who are just down the street from me. Probably one of the handful of preeminent specialists in this area. So we're going to be talking, there's the title of what we're going to be talking about today. You are free to ask questions. If you play with your mouse, you'll see that there is a Q&A functionality. You're free to ask questions, preferably in the Q&A functionality, not in the chat, because then we can identify question by question rather than this long flow of chats. So feel free to ask questions. We'll answer them at intervals during the session, and rather than when they come up, to allow for the flow of the conversation, to offer a better flow. So having said that, let's begin. So first of all, the agenda today is here. We're going to have an introduction from the speakers. Then we're going to briefly talk about really, I think, what is the trigger for this webinar. It is the post-election reality in the United States, especially as it relates to estate planning and the use of trusts. Why use a trust? The legal and tax issues of trusts, reporting, and this is going to be from the US and Israeli point of view, which makes it particularly of interest, we believe, and hopefully most valuable. So we'll start. My name is Monty. I'm a US tax lawyer, got my degrees in BA and JD in the United States. And for the last 20 some years, I've been offering and providing predominantly tax advice or tax counsel on to Americans around the world and to non-Americans who have investments and things like that in the United States, who have a nexus to the United States. A lot of it involves higher wealth individuals and providing really cutting edge solutions which are tailored for the American as well as for the local law, because there's no point in me providing a solution for an Israeli living in Israel if it doesn't coincide or doesn't come together with the Israeli side. And that's a very important issue in everything I do, is what is the local law as well, especially in trusts. I worked at the IRS when I started in Boston after law school. The first thing I did was I was assigned to a very small part of the case of the owner of the Boston Red Sox, Jean Yawkey, who died when I was at the IRS. She owned the Boston Red Sox, the Fenway Park, a very rich woman. And all I did for 2 years was go through her trust, because all the Boston Red Sox and all of her assets were owned in trust. And the issue of minority discounting, when you divide assets into different trusts and each one owns a minority interest, we'll get into this. So this whole subject really kind of allows me to understand, number one, the real sophisticated planning around trust and estates and gifting, and something that is to really allow me to get my teeth or myself wet on a very high profile case in Boston. As you know, Boston's a sports town. So that's myself. Shira, Trevor, why don't you briefly introduce yourself?
So just in a few sentences, our firm is basically specializes in multinational cross-border family planning. We also have a very strong base in Switzerland, Zurich, where we have our trust company and asset management company. And we basically represent families and high net worth individuals worldwide with everything they need, from the structuring, the tax advice, the estate planning, the asset protection side, the wealth management side, and preservation. So basically, we have so many situations, the typical Jewish family with parents immigrating to Israel or living in the US or South Africa or England and have children living in various jurisdictions, be it Israel, America, or South Africa or England, and they basically need the the cross-border family planning and estate planning for the various assets, especially in this day and age where we have the common reporting standard, which is the exchange of information between the various jurisdictions, and basically every jurisdiction with its own tax rules, especially when it comes to trust. So basically, this is what we specialize in. We have a staff of over 60 people here in our group, which this is what we do, and basically hold the hands to the families we represent and all the aspects and needs that they require, both in Israel and internationally. And it's a pleasure always to have the emphasis on the US side of things, because we always say that the US is a separate jurisdiction and we always take separate advice when it comes to the US. So Monty, this is obviously where you fit in with our collaboration. And we look forward to many more.
Okay, thank you. If I can just ask you to maybe move a little closer to the mic if you can, just a little bit, to your voice will be all that clear. And if you don't, I can understand everything you said, but I want
the it's fine. I can't see anything. So is this okay?
Perfect. Yeah, speak up. Perfect. That's you. Okay. So let's start then. Okay. So we're talking about the post-election environment. And I think that there you have the quote from Yellen, who was the Secretary of the Treasury in the United States. This came out, when was it? 10 days ago. She defended Biden's plan to reduce the exemptions from 11.5 million to 3.5 million, and also to increase the top rate to 45%. They're also talking about the end of the step up in basis under American law. When the person passes away, the heirs receive that asset at fair market value at the time of death. Okay, so in the future of any capital gains, it's only measured from the fair market value at death. So you pay estate tax, supposedly, but also you get a stepped up basis. Those are things, at least the first two of the tax exemption and the tax rate, are going to change. How much they're going to change is really going to go down to 3.5 million. No one knows, but it is going to change because it went up from 5.5 million under Trump, and that was the jump was just really kind of astounding. But that's the Republican, way of doing things. So those are that is the trigger for this webinar, because I know that and the trust companies that I've been working with for Americans have seen an off the chart gifting way of assets, because people want to gift things away and enjoy the higher exemption. Of course, the issue is retroactivity. We will touch upon that in later on when we get into that issue. When I say retroactivity, I mean if I give a gift today and the law reducing the exemption goes into effect tomorrow, but retroactive to January 1st, 2021, what happens then? We'll talk about that in a second. But as we say, we're seeing a huge amount of gifting and a lot of it into trusts. Now, in general, again, you're free to ask questions. I'm going to cover a lot of this on the American side. I know that Shira and Trevor have vast experience because around the world and not with Americans and with trusts. So feel free, Shira and Trevor, to come in and
yes, I just wanted to just say one comment.
Yeah, sure.
Everything you just said is that Israel doesn't have gift tax and it doesn't have inheritance tax. And that will come in later.
Okay. So
this is America that does. Okay. And when it comes to dual citizens, that an Israeli wouldn't have a gift tax implication or wouldn't have an inheritance tax implication. But if he is a US person as well, what that means in the context of both jurisdictions.
Mm-hmm. Yeah. So we're talking about in general of an area which is extremely intricate, as we'll see here, and especially when you're talking about cross borders. So as the introduction slide said, nothing here is legal advice. We're giving general ideas and general summaries of the law. but this area is extremely intricate and nothing here is legal or financial advice. Okay, so why use a trust? First of all, in the vast majority of cases, we're talking about a family, a wealthy family. The owner or the head of the household has a business or has a corporation or some kind of partnership or whatever with a lot of assets, real estate assets, business. We'll talk about business and real estate. And so the person wants to convey that to the next generation. That raises a whole bunch of issues of control, of competency of the next generation. Which of the sons or daughters is the one who's in the business? How do you give? These are things which are significant and very fact specific. Or you can have a person who has a lot of cash and an American or securities, and they don't want to give it outright to their minor children, of course. And then there's issues of the children and the spouses of the children and how to address those issues. So there, again, we're talking about a wealthy family that the head, someone, the elderly, the matriarch or patriarch, either wants to convey, transfer assets to the next generation, and they want to do it wisely. They don't want to give an outright gift because the younger generation is not ready, but they want to give the gift and enjoy the benefits of giving the gift, but they want to do it in a controlled manner, which does not harm the assets and is done in a way which is wise for the family environment. When it comes to America, because of the estate tax, this issue is of paramount importance because of Boston Red Sox. I mean, anything. It doesn't have to be the Boston Red Sox. If the estate tax goes down to 3.5 million and you're married, let's say, and that's 7 million, and you have 30 million and you're an American citizen, that's 45% of going to the government for estate tax purposes. So without a doubt, for Americans, the issue of estate tax is central of getting as much assets out of your estate in a manner which is wise, considering who you're giving it to and control issues, and getting it out of that environment of the estate tax. And we'll get into how to do that. The second crucial issue is evaluation. When Yawkey of the Boston Red Sox or my clients have several, how do you value a gift, which is not dollars and cents, real estate or a business? The gift is valued at the date of the gift, okay? How do you value shares in a closely held corporation like the Boston Red Sox? And so you have a wide variety of considerations, especially if you're giving minority shares to different children, because the test for fair market value under the IRS is fair market value. What would a willing buyer give a willing seller for that share? And if you're giving a minority share of a business, 20% in a business, to 3 different children, maybe together they may have control, they have 60%. But what is the value of the share that each one of them gets? That's a minority share. And what would a willing buyer pay a willing seller for a minority share? Significantly less than what control conveys. So the issues of valuation, especially in Corona, where the government is really busy with major issues, and this area of valuation is by far, putting aside control and how you structure the trust, valuation is a key factor, the key factor in really taking advantage of minority shares and in closely held assets, without a doubt, okay? Why don't the two of you talk about a little bit more about, these are, of course, things which are central to a trust, asset protection, privacy. If you guys want to, share a few nuances from your experience and talk about that, please go ahead.
Sure. Yes, we advise and assist many families with their estate planning and asset protection, and the utilization of trusts is very central to that, and the advice that we give to them. A trust is unparalleled in what it can offer to a family. As you've already said, Monty, the generational planning, the protection of the assets for the future generations. It protects not only in terms of in terms of like an estate planning protection. There's a protection against creditors. There's the protection of irresponsible beneficiaries, and
there's no need for probate, for example.
Yeah.
Basically skips the need for probate,
Yeah.
which can cause family to object.
Probate can also be a very tricky thing to obtain, especially in certain countries. Israel is particularly difficult with foreigners with assets in Israel. Other countries as well, we have many situations where probates are going on and they take an extremely long time to deal with. So having things having assets within a trust can avoid that and help on the passing of the assets to the next generation. And there's just very much a protection and a safeguarding of the assets for the future. Trusts these days do not, they either have an extremely long perpetuity period, the period they can continue for, or not at all. There are certain jurisdictions which don't have even a perpetuity period, and they can continue for as long as they are relevant. So it's very, very much a long-term planning, and we think that for high net worth families, it's very essential these days, very essential way to deal with your estate. As you said, Monty, there are certain aspects which are beneficial from a tax perspective, from an estate planning perspective. There is also something within the Israeli law which can be of benefit to Israeli settlers, and we'll touch on that a little later on. And what else can I tell you? One more point just to make is that in Israel, any settlement of assets into a trust is not considered a taxable event. So there are no, it's completely tax neutral.
Okay. Trevor, let's stop here 1 minute. We'll get into the tax in a second. So I agree with everything you said, and I should even put the bullet in there. The probate, privacy, especially on international matters. Assets in trust don't go through probate, aren't open to the public eye. In international settings, the probate is a major headache. I give a lot of expert testimony or opinions, or I'm sure you do too, on UK law or around the world. I do for American law. It saves huge headaches. Okay, why not to use trusts? Well, they're a little more complex than a will, because you have to put together a trust. It involves attorneys. It's not just a will, but and there's costs involved, not significant really, but there are of course complications. But without a doubt, the benefits for the person for the family that has these considerations by far exceed the relative complexity. Okay, now I'm going to be talking about the U.S. side, and each side I'll allow Shira and Trevor to also pitch in where it's relevant. But as a general law, as a general rule, there's just different kinds of trust from a U.S. perspective. And this is high level stuff. First of all, there's a grantor or non-grantor trust. Basically, it means who is deemed to own the property. I put this stuff in trust. In America, a living trust is a revocable living trust is very popular. The owner of the assets puts them in trust to avoid probate, but the owner of the assets, even though they're in trust, is still deemed the owner when they're in trust. That is a grantor trust. A grantor trust is where the person who gave the assets to the trust is still deemed the owner for estate tax purposes and for income tax purposes. That accomplishes nothing. A grantor trust, by and large, for estate planning purposes, setting aside avoiding probate and privacy and asset protection, does not accomplish anything from an estate tax point of view, because again, grantor trust, the owner is still the individual for tax purposes, okay? And that is very different from the non-grantor trust. The non-grantor trust is a separate entity for tax purposes and legal purposes, of course. And the owner for tax purposes is not the individual, but the trust itself. Now, how do you distinguish between a grantor trust and a non-grantor trust? The Internal Revenue Code is very clear. Section 672 to 679 of the International and the IRC, the Internal Revenue Code, specify these exact powers, where if the grantor, the person who set up the settlor, grantor, the person who sets up the trust, maintains any of these abilities, the rights to revoke the trust, and if the grantor still get beneficial interest of the assets, or if it gives the person the right to change beneficiaries, those are by code in America grantor trusts. And again, they may accomplish a whole variety of things, avoiding probate, but they do not impact the estate tax issues or tax issue. Very important, okay? Grantor trusts help, but not with estate, with the real core issues of why many Americans put this thing into trust, when they put things into trust, okay? So that is one type of trust, the grantor versus non-grantor. That is really a fundamental thing. The other one, which is really important, is a foreign versus U.S. trust. And how do you know if it's a foreign or U.S. trust? America has two tests which determine whether it's a foreign trust or U.S. trust. And as we'll talk in a minute, from a tax purpose, for tax reasons, a foreign or U.S. trust is a very important an issue. So the two tests for U.S. to determine if it's a U.S. trust or foreign trust are the court test and control test. Both of them must apply for it to be a U.S. trust. If both of these tests do not apply, it is a foreign trust. The same is true for grantor-grantee. If it is not a grantor trust, by definition, it is a non-grantor trust. The same here. If it is not a U.S. trust, by these two tests, by definition, it is a foreign trust. And there you have the test. Does the U.S. court have primary supervision over the trust? And who controls the trust? What happens if there's two trustees? What happens if one moves up? These are endless fact patterns that we cannot get into. But these are the two tests, okay? So Mike, Trevor, and Shira, if you want to talk about how you encounter these things when you draft a trust, why don't you briefly talk about that? And Shira, if you're going to be talking, I've had people ask for you to speak up or just bend forward. And
yeah, I know I'm speaking up, so I hope
Very
I don't know
good.
what. I mean, otherwise I'll shout. I don't want to shout. So I hope that it's better now. So basically, we basically create the classic foreign common law trust, which usually we have our Swiss trust company in Switzerland, and the governing law would be BVI or Cayman. But basically, when it comes to Israel, I'm just going to put in the Israeli
Oh, very
context
important.
always. Really, the issue is who is the settlor grantor and who are the beneficiaries? Because while Israel doesn't really have a very strong equity and trust law, it just has a very old 1979 law. It does have a very strong taxation of trust system within our income tax ordinance. And so basically, when it comes to anyone with an Israeli connection, being an Israeli grantor and settlor, also with the US tax status, or Israeli and or foreign beneficiary, we actually look for taxation purposes, who the settlor is and who the beneficiaries are. And from there, we structure in the tax assessment of that trust and the tax status of that trust for the Israeli income tax ordinance purpose. And again, as Trevor said before, a key benefit for the need to create trust from the US side of things is that it's not a taxable event in Israel. So the actual settlement of assets into a trust does not create a tax exposure from an Israeli point of view. And that's obviously something very important because you wouldn't want to have a clash.
Yeah.
You would need, from a US point of view, to settle assets into the trust and create a major tax accident and tax exposure here in Israel. So that at least is something that you wouldn't have to tackle. Of course, there's other tax issues to think about and to consider from both jurisdictions, and we can discuss that later.
Yeah.
And just to add one
Sure.
more point in that, you were talking before about grantor and non-grantor trusts and the elements that make it determine whether it's a grant or non-grantor, and the continuing influence of the grantor. That will also be something that is relevant to Israeli trusts that are settled by Israelis for foreign beneficiaries, and we will talk about that later on in the presentation. But that idea of control is something that will also be relevant here in Israel for tax purposes.
Yeah, the whole issue of the influence of the settlor, I mean, through protectors and investment
That's irrelevant
advisors.
in Israel these days. That they don't look at that anymore. So that control is only relevant if you have an Israeli settlor for foreign beneficiaries. Other than that, there's control is just a non-issue.
The control issue for whenever we are dealing with trust, the control issue is always about whether or not the trust is a real, effective trust, or if it's just a sham.
Yeah.
Whenever the more control that there is, the more evidence or arguments that there could be that this is a sham, and therefore you want to retain all the protective elements of the trust. So you want to reduce the control where you can.
Yeah. So I don't even get into that because the American law is so well defined that if it's a sham, it doesn't have to be a sham. If any one of these things, these elements are there, it's a grantor trust. So the American law is so well defined that if someone's going to come and with a lot of assets and start trying to shave off or trying to assert control, it is not good. There's legitimate ways to structure control through protectors and invent all whatever and independent trustees. But when we're talking about gifts to trusts or to individuals, these are, from an American point of view, there's no playing around. These are gifts. They're not half gifts. They're not, all kinds of combinot, as we say. No, in America, that doesn't jive. America, and we're dealing with people gifting millions of dollars. You don't do that under American law. So that's what I love about American law.
So I'll just add to that while there's no gift tax in Israel and there's no estate tax in Israel,
yes,
the eyes is always going to be from grandfather to father to child. So if there's uncles, giving gifts. If there's brothers and sisters, giving gifts. If there's business partners, giving gifts, that's a different ball game. So I can't say there's no gift tax in Israel, so anyone can give a gift to anyone. Because the Israeli tax authority is not going to look in a good way at an uncle giving a gift to a niece, or a brother giving a gift to a sister, or a business partner giving a gift to a business partner. So that's very important also just to note. It's just the generation. line.
Okay, next issue. Now we're going to get a little more into tax. Not into estate tax, not so, well, whatever, into tax. So first of all, as I said, the grantor trust is basically invisible for purposes of income and estate tax because the grantor is considered owning the assets. So we're only really focused on when we're talking about estate planning to achieve tax objectives, we're basically talking about non-grantor trusts. And a non-grantor trust is a separate entity, and it itself is taxed on the income. So if the trust is sitting there with income, with stocks, bonds, dividend, real estate, it is a separate income from the grantor, and and it owns the assets. That's why when the grantor passes away, there's no estate tax, and why when there's income, the trust itself is taxed on the income. Okay. Now, on the other hand, if that trust, the non-grantor trust, distributes that income in the year it was earned, it gets a deduction from it gets a deduction. And if it distributes all the income, it doesn't owe any tax. It has an obligation to file a return, but there's no tax owed because it has $100 in income or $1 million in income. It distributes all the money to the beneficiaries, and it has zero net profit, whatever you want to call it. Okay, and it is the beneficiaries who are taxed on the distributions they receive, if, of course, they are American persons. If I am a non-American, put money into if the bottom line, if the beneficiary is not American, then they don't pay taxes in America. Where they pay taxes, I don't know. I'm talking from an American point of view. I'm a U.S. tax attorney, not Switzerland or anybody else. So if the U.S. beneficiary gets that income, the U.S. beneficiary pays the tax on that income. Okay, now the question arises, what happens if the trust earns income and distributes it sometime in the future? Headache, big headache, because under U.S., it happens all the time. I'm not saying it doesn't happen, but there are the U.S. tax law is built to penalize the holding of profits inside the trust and not distribute it to the beneficiaries. The U.S. wants to tax people when that income is made and earned. So you can hold it in the trust all you want, but when that money is distributed, there's going to be higher tax rates, interest. It's a very complicated regime. You know, it's complicated. And so to the extent you can avoid it, like let's say a rich family puts a privately held company into a trust. The corporation can earn anything it wants, but until that money is distributed to the trust has no income. So, and of course, that policyholder corporation can pay salaries to its employees and family employees without the trust earning anything, because on the salary level, it is the employee who's getting the money, not the beneficiaries. And when there is a dividend, so long as you send that dividend out and distribute it to the trust, and the trust gives it out to the beneficiaries, there's not this whole thing of holding money inside a corporate in the trust does not arise. And it's best if you can to avoid that situation. It's not the end of the world, but just so you know that if the U.S. trust does not distribute all its income, that's a different regime that has to be dealt with. Shira and Trevor, do you want to just add anything on the Israeli side?
Well, there's a lot to add on the Israeli side, so we'll have to make it sweet and short. But I'll just give a few tips to families planning. Okay, one of the more difficult situations and hurdles we have seen, and this does cause for premature planning in advance, is a situation with mixed beneficiary trust.
With what?
Mixed beneficiary trust, which means beneficiaries that are fully Israeli only or only Americans. Because unfortunately, the Israeli income tax ordinance defines trust where there's at least one beneficiary. So I'll just go for situation with US grantor, 20 US beneficiaries, and one Israeli who made Aliyah, okay, or two Israelis who made Aliyah. The grantor passes away. Under Israeli law, the entire trust, 100% of the income, assets, etc., become an Israeli resident trust for tax purposes. It suffices that you have one Israeli beneficiary. And so one of the strongest recommendations we can make nowadays is in advance to split, not to have Israeli beneficiaries mixed together with US beneficiaries. Create a separate trust for the Americans and create a separate trust for the Israelis. That's number one. When it comes to those types of trusts, there's two methods of taxation. When the grantor is alive, you have to choose one time, and it's the trustee that has to choose whether to have the trust taxed in Israel on an annual income at 25% or on distributions to Israelis at 30%. We do have the treaty between Israel, the double taxation treaty between Israel and the US that does specifically include the word trust in it. So we know that the double taxation treaty does apply to trusts, but there will be arguments between who has the right to first taxation between Israel and the US. It depends on the assets and where the assets are situated. Again, advice is needed here. That depends on the examples, and obviously we can't go into it today, but a top recommendation would be to split beneficiaries into separate trusts, not mix them together. And that is a tax accident to avoid in advance. And if it's already been done, it's a problem. And again, advice should be sought. Reporting obligations. Any trust having an Israeli beneficiary or an Israeli citizen.
We'll get into reporting in a second, Kira. We'll get into
but I mean, I would say, Trevor and I would say when we were discussing, our strongest tip today would be not to mix beneficiaries.
Yeah.
I mean, that is avoiding in advance a very big tax accident in both jurisdictions.
Yeah, I would agree again for the reasons I said. When you have, for a whole different reason, the minority discount, if you have one trust which holds everything, then you don't get a minority discount. And that increases the value of the gift by 30%, 40%. So people that
goes both ways.
It doesn't make sense in these situations where there's a substantial money involved, or 30, 40 million, doesn't have to be billions, to create separate trusts. And especially if there's one of them is a beneficiary is a US citizen, one not, major issues here. Okay, so I agree that, I mean, so it appears that on both issues, for both jurisdictions.
Very valuable thing to do.
Very valuable. Okay, the next issue is this. Okay, now I talked about foreign versus non-foreign trusts, and this is a big one for reporting issues and for tax issues, because under Internal Revenue Code 679, a grantor, a person who puts money into the trust or assets to a foreign trust, is deemed the owner of the trust income if there's a US beneficiary. Okay, so an American person puts assets or money into the trust, it's a foreign trust, and there is a US beneficiary, or potentially could be a US beneficiary, then that person is considered the owner of the income, not of the estate, not of the property. So they're okay for estate tax purposes. If it is a non-grantor foreign trust, they are okay from a estate tax point of view, but from an income tax point of view, they are not. Okay, and we'll get into why that has implications in a second. Very important issue. Okay, now what does that mean if there is or could be a US beneficiary? Is exactly what I'm saying. if there is basically not a clear statement in the trust that says, under no circumstance can there be an American beneficiary, then conceptually there could be a US beneficiary. Now, if the beneficiary is a child who you cannot renounce his or her citizenship until they reach age 18, and then what happens at the age of 18 when they renounce, okay? So these are all kinds of different scenarios, but we're talking about income tax, not estate tax. Nonetheless, okay, so that is a major issue. Now, what about other things on this specific point? For income tax, it is considered owned income by the grantor. But what about for PIFIC? Or what about for the Obamacare 3.8%? Or what about controlled foreign corporations, which I, have been pretty involved with litigation in America and advocacy. What about those things? If there is the potential if there's a potential for a US beneficiary and that stock is owned by the individual, deemed owned by the individual, because there's a US beneficiary, does that grantor have liability for PIFIC? Does that person have liability for NIIT? Because those are all income tax related provisions, okay? Very tricky area of the law, because each one of these different areas, PIFIC, NIIT, and CFC, control foreign corporations, as we all know, are very intricate from a US point of view. So in using a foreign trust, where there's a US beneficiary, how do those tax regimes impact the trust? Major issue. The other issue is that of reporting. As we'll see in a second, there's also reporting for foreign trusts, which don't exist for the US trust. So now we'll take a break here. What we'll do is, before we get into the dirty, nitty-gritty Israeli stuff, if there's any questions, people have asked questions. We'll take a short break now. And okay, so there's a question here for Shira. So, and Trevor, when do you ever use an Israeli trust? I know I'm not a genius on Israeli trust law. I don't know anything about it, but do you ever use the question is, do you ever use an Israeli trust? Is there such thing? And when would
No, so one of the problems with using the Israeli trust, unfortunately, is that it clashes with our inheritance tax law. Because Section 8B or A of our inheritance tax law says that after the demise of the testator, or basically the assets returned to be part of their estate. So therefore, we personally, in our firm, and this is the view that I take, I don't believe that an Israeli trust survives the demise of the testator. So this is why we only create foreign trusts. We don't believe that the Israeli trust has the real needs and fiduciary duties and everything that's required to basically govern trust laws appropriately. So we form foreign trusts, which when it comes to Israel are guided by the income tax ordinance and their taxation status. And I see that there's a question there about charitable distributions. It's a very, very big problem that we present to the Israeli tax authority. Unfortunately, even when trusts make distributions to Israeli charitable organizations, it is at the moment considered to be a distribution and therefore could be subject to tax. There is tax exposure there, and we think that it's really something that needs to be addressed by the Israeli tax authority, and they are aware of that, but it's a problem at the moment.
Yeah. Okay, so I see that question about because we're covering a vast amount of everything to do with charitable deductions, charitable giving. It's a whole different thing that I'm from a US point of view, because the law is so broad. I'm gonna and Gershon asked about generation skipping issues.
Absolutely, and I also see a question about the tax treaty trust.
One second, so I'm just saying, from a US point of view, because the law is so complex, generation skipping tax, charitable issues with trusts, major issues. great planning opportunities. I, from a US point of view, will not address them today. Shira and Trevor, if you want to talk about from the US side.
No, I just mentioned that it is a problem in Israel as well. And the Israeli tax authority, as far as the double taxation treaty, as far as Israel's concerned, a trust is a trust. And if there's an Israeli settlor or grantor or Israeli beneficiary, there's tax implications in Israel, full stop. They won't consider it just to be a US issue.
Right. Okay. So I'll just go quickly through. So there was a question about money in a Fidelity or Vanguard. That I don't see how that relates to tax, and whether you should worry about something. You know, we all like worrying. You have a constitutional right to worry. I won't prevent you from worrying, but I don't see the connection to tax. You will take that offline. Residency issues. I'm not going to get into Shira. I mean, they're talking about something about where was that question I saw about dealing
I
with
saw just a question
tax
about
authorities.
the
1 second, let me find that question about the tax authorities. Israeli tax authorities. No, okay. So will Douglas asked, will 3.5 apply to widows if their spouse died under the $11.5 million regime? No. If a person died before, under the $11.5 million regime, the law which governs is the law of the date of death. The question is, what happens? No, so the answer clearly, Doug, is no. When a person dies, that's the law that governs. The question is, what about gifts? Because if I give a gift today and I'm assuming it's $11.5 million exemption, and I'm based on that belief, on reliance of that, I give 11.5 million, and then the law changes the next day and is retro, I've been screwed. Okay, can that be retro? The retro only applies to gifts, and that's a touchy area. The IRS has hinted that it will not seek, the Treasury has hinted they will not seek retro, but the Democrats are in control, and if they can, if there's big estates out there, I don't know. Okay, so that answers your question. Let me see, is there any other? Rivka, you asked about reporting. We'll get into that. Jason said it's an amazing session. Thank you. Okay, so let's continue. Okay, I think we've exhausted most of the questions right now. So let's now get into your two slides here and just go and take it from here and go.
it's just in very, very short terms, because again,
as loud as possible.
Sorry. So basically, any trust, if you have a US dual citizenship and an Israeli citizenship as well, if you're settling a trust or you're a beneficiary of the trust, you need to take advice on your reporting obligations here in Israel. And trust will be taxed in Israel. Where it won't be taxed in Israel is if it's irrevocable trust and it's an Israeli settling in favor of foreign beneficiaries. That trust, if it meets certain criteria, will only be reported in Israel and will not be taxed in Israel. So if you have an Israeli citizen with US children or grandchildren and they want to create a trust for them, that trust will be exempt from tax in Israel. And the assumption is that there's no gift tax and inheritance in Israel, and that is a very good instrument to use for taxation purposes. And again, basically, all the taxation of trust is guided in Amendment 197 and Amendment 168 to our income tax ordinance. Again, advice is always seek, but again, what Trevor and I basically wanted to emphasize is the need to split the beneficiaries, the need to know that the trust must be reported here in Israel, even if it's paying tax in Israel, in the US, even if it's covered by the double taxation treaty. If you don't report here in Israel, you're subject to fines. And basically, it's the trustee that needs to report the trustee in Israel. It's the trustee that has the obligation to open the tax file within the Israeli tax authority. So an Israeli grantor settlor can also opt to report personally. But there's a whole need to get advice on the Israeli tax ramification and Israeli reporting ramifications. So if anyone thinks, we're paying tax in the US, it's even more than what we would be paying tax in Israel. Know that by not reporting the trust here to the Israeli tax authority, it's both could be a criminal and civil offense, and also subject to fines that can build up and build up and build up. So that is something that whenever you create trust with the Israeli or US element, it's important to get the tax advice and know what the tax consequences are in both jurisdictions.
Yeah.
And just to add to that, if I can just add one more point, the second paragraph there talks about splitting the trust and splitting out the non-Israeli beneficiaries, and that is something that people often think, what do I need to take advice here? I can just do this. Who's going to know? Who's it affecting? I'm just going to exclude the Israelis, or not report them, or just. Well, I guess this would be actually an actual splitting. So it'd be excluding the Israelis, taking them out, and people need to understand that the Israeli tax authority are very aggressive in their approach towards trusts, and this splitting cannot be done without their blessing and agreement. And doing a splitting of the trust yourself could be a huge taxable event here in Israel.
So for existing trusts that are already out there, they have Israeli and US beneficiaries mixed together as a class, even if it's after the demise of the grantor, that is a nerve that's hitting a nerve to the Israeli tax authority. And that's where basically I would say that today that's the top advice that we give on situations like that, because that is a problem.
I hear you. It's it's so axiomatic for me, because I deal with Americans around the world, and they live in. If you do, and trust by definition, is larger money, and American IRS Treasury, they're after the larger money, and the trust as is, or looked at with suspicion. You've got to do the right thing.
Another very sensitive issue, which unfortunately, when you said the word combinot, but unfortunately that really was done by Israelis, which is actually quite sad. But what they did was that they put assets that were theirs on foreigners, and would say, they're the foreign settlor, it's not mine. And that's obviously something that's a complete disaster when it comes to Israel and the tax authorities. So those are also situations. Those are the situations that basically hit the nerve on the various tax authorities. And another issue is, again, which I mentioned earlier on, but I want to stress it today, there would be some kind of fight between the jurisdictions on who would have the right of first taxation on the trust, Israel or the US, depending on where the assets are. So obviously, if it's real estate in the US, Israel would know that US would have the right of first taxation. But when it comes to shares or assets out of the US, and you're creating trust where there's an Israeli and US grantor settlor beneficiary, then you're up to what the Israeli tax authority would think that they would have the right to tax first vis-a-vis the US, the IRS. So those are also things that we need to advise families on, and their accountants and reporting obligations, etc.
Monty, before we move on, just one more point, just while we're on the topic of the Israeli trusts, is something that people often don't know, have a misconception about, and that is what it means to be Israeli. People often think that Israeli means that they have made Aliyah, that they've got their Israeli Tudat Zehut, their citizenship, but that is not necessarily the case. We are dealing with some very, very difficult situations at the moment with trusts where the beneficiary did not think that they were Israeli. They thought, I'm living in Israel, but I'm not Israeli. I haven't made Aliyah, but that is a misconception. The determination of whether or not somebody is classified as Israeli is not based on whether they've made Aliyah, but is actually based on their residency. So people, whenever families are thinking about trust and thinking about, and trustees are thinking, do I have an Israeli exposure here? They actually need to be thinking about, well, who do we have as a beneficiary or a potential beneficiary who's actually living in Israel, irrespective of whether or not they've actually made Aliyah or become a citizen. And that is something that people really should
very important issue. And that comes up in America too, because let's say a child is born, does that child automatic to American parents, or is that child automatically deemed American? These are very touchy issues. When is a person American? Okay, we won't get into that now, and I really want to end up with okay, I'm going to just go very quickly because I really try to keep these things to an hour, and we have 3 minutes left. So reporting, U.S. reporting. If it's a U.S. non-grantor trust, that trust files U.S. tax returns like any other taxpayer. If it's a foreign trust, then you have the Form 3520, which you have to report transfers to, distributions from a foreign trust. And that's filed independently from the beneficiary's tax return. Okay, so there's a lot of reporting that goes on with the foreign trust, not only the problem of Section 9, it's 679 that we talked about. And then the question here of who's responsible for reporting to the Israel, in a sentence, let's try to keep this short. Who is responsible for that? Shira, who is responsible for reporting trust issues?
Okay, so as I said before, the trustee, according to our income tax ordinance, it's actually the trustee. The trustee has to open a file, obviously within the study that, I mean, I'm not going to go into all the technicalities, but the settlor, if he's Israeli, can also opt to be the reporting party.
Okay, so here, so anyways, regarding the United States, without a doubt, there are issues in having a foreign trust, the reporting, the Section 679. But on the other hand, there's many benefits to having a foreign trust. It's a case-by-case situation. The last thing, other court, okay, I'll just, as I said before, if the trust owns shares and those shares generate a company, we'll say a company or a minority share interest in the company, what does that say about CFC and Subpart F income or GILTI? If you're an American, you may know these terms. Who gets attributable? Who has to report the Subpart F or the CFC and the GILTI? The trust, okay? PFIC, we talked about, but okay, another major issue, and this is going to be, I'm going to have a different webinar just on this issue of attribution. How do you know who the owner of the trust is? Is it the beneficiary? Is it attributable to the parent? When is it attributable to the parent? The whole issue of attribution is a major issue in America, and it's very well legislated, and there's regulations up the yin that talk about attribution. Who owns the shares that are in the beneficiary's name? Okay, usually it's the beneficiary if it's a non-grantor trust, but for purposes of other taxes, those are issues you have to look up. Okay, so I think what can be done, we'll end, this will be the last slide. First of all, before the law changes, given the election result, U.S. persons who have potential U.S. estate and give exposure have to start asking the questions. I'm not saying doing anything, but ask the question about this whole gifting thing and use of trusts before the law changes. Just ask the question, okay? Gifting, valuation, major issue, control, retroactivity of the law. These are all issues to be dealt with, which I think that now, because of the U.S. tax elections, And what is on, they're on record, Biden and Yellen, of saying, it's a good time to at least ask the questions and ask people who know. I mean, for yourself and your family, is this something I want to do? Will it benefit me? And will it benefit my family? And in many cases, the answer will be, if you're an American with exposure to estate tax and gift tax, and you have any connection to Israel, the answer is yes. Good time to raise those questions to your family office, to whoever it is who's your financial advisors, to get questions to that. That is, here's our contact information. We'll take a few questions and there. This video, I never share the video myself. There's a recording which has been made, and I know that Shira and Trevor asked if they could gain access to it. I never share it, but if Shira and Trevor want to provide it to on their website or whatever, then we'll work this out and we'll send it out. The recording, the presentations are always available. Trevor, Shira, and I will send out the presentations. Recording, I'll let Shira and I and Trevor decide that offline. Okay, some questions. So let's start with the Q&A. Trevor and Shira, let's see some questions that have come in. So the Israeli grantor with US beneficiaries will not be taxed in Israel. Do you see that? Why don't you just...
The answer to that is, in principle, that can be achieved, where you've got a Israeli grantor and only US beneficiaries. There are some technical criteria, and we would need to take professional advice and to check the trust deed, make sure that the control issues are not there. But in principle, yes, that is achievable. And that is actually something it's a very, very good and effective tax planning tool to enable foreign beneficiaries to benefit from a trust and from the accumulation and the growth of assets within a trust without it being taxable in Israel.
Okay. There's a question here about twice, Yona, you've asked, what about a foreign non-grant or trust? I just don't understand that question, because an NGT is a non-grant or trust. It's not a chevra mishpachtit. So if you want to ask me that in an email, I'll be happy. I just don't understand the connection between the non-grant or trust and chevra mishpachtit. Those are two different things. So Jason, what are your thoughts about Biden's plan, and will it be retroactive? I think I've talked about that. Mohammed asks, if a non-US citizen has created a trust, which would be a foreign non-grantor trust, if he was an American, what would happen once he becomes a US citizen by getting a green card? A non-grantor trust has nothing to do with whether the person is an American or not. So it's hard for me to understand that fact pattern and what would happen when he becomes, Mohammed, I just asked you to send me an email. It's just very difficult for me. Could it be, David, could it be more risky in relation to tax authorities for the US person to be part of a trust? Would it look bad? If it's done right, look, trusts are raise red flags because there's always, but on the other hand, everybody in America and their mother has living trusts. So if it's done right, there's nothing to worry about. Of course, it raises red flags.
I agree.
Yeah, if it's done right.
There's nothing against trust. It's
nothing against trust.
If they done properly, and if they basically abide the common reporting standard rules, they reported correctly in the various jurisdictions, and they set up correctly, then a trust is fine. The problems are if there's something that's not done correctly.
Yeah, and from what I've heard you talk about, an Israeli kombina mentality, this is not an area I don't like Combina in general. And as a tax lawyer, I can invent, I have innovative solutions, but I don't believe in Combina, definitely not in this area. Okay, chat, here. Can Shira explain again the favorable tax with grandchildren that is favorable in Israel? Do you understand that?
Well, no, I don't know if the grandchildren are here or in America, but again, it's what Trevor said before. If the grandchildren are, for example, in the US, then there can be an enjoyment of a non-taxable trust in Israel if it falls into various criteria. Again, if there's grandchildren here and there, not to mix them, that's something we talked about, but it's a bit vague. I mean, I would need specifics.
Okay. Karen, you asked a question about investing, double taxation, but that's unrelated to trust issues, so I'm not going to get into that. Any advice for dual U.S. citizens as beneficiaries? That's a very broad question.
Yeah.
I think we'll end here. Yeah.
If you're Israeli and you're a beneficiary of the trust,
Good advice.
you need to get advice. It's reportable here in Israel and it's taxable in Israel, question mark.
Okay. So I'm clicking